So before understanding the concept of how to divide and settle the family property, it is better we must have an example to understand it better. Let us assume the head of the property, father, died leaving behind wife, a daughter and 2 sons. And assume there are 4 properties A, B, C, D. Now because he died intestate, that is without writing a will deed, everybody will have right in the property. All the 4 family members will have the right in the property. But for some reasons, mother and the daughter doesn't want any share in the property. So therefore, they can settle, all the 4 family members can settle the 4 properties A, B, C, D orally or in writing. So if they wanted to settle orally, that is, all the 4 properties will be enjoyed by both the brothers. Then what must be done? Both brothers will take possession and they will mutate their name. Instead of the father's name, they will mutate their name in the revenue records or the municipal records. Now, there is one problem in the oral family settlement. Tomorrow, sister's family could raise a dispute for her share. At that point of time, what is the remedy the brothers have? In the past 70 years, there were many cases before Honorable Supreme Court. One of the recent case which is decided by the Honorable Supreme Court, upholding the principles in the past 70 years pertaining to family settlement and the guidelines pertaining to family settlement, I have given in the description box, kindly go through it. Now, the main pitfall or main disadvantage for the oral family settlement is that one of the family member, here in our case, the sister is claiming a right after some period of time. Now, what will courts do in that point of time? Courts will take out a principle called the principle of estoppel. What is principle of estoppel? Estoppel means courts will not allow the sister to somersault. That is called the principle of estoppel. So, once having given a word that she has no objection for mutation in the name of the brothers, in the revenue records or in the municipal records, tomorrow the sister can't question that family settlement. So, in the simple layman terms, the principle of estoppel means you cannot go back on your word. So, the oral partition has this disadvantage, and this disadvantage will be redressed by the court using the principle of estoppel. Hope I am clear when oral family settlement is done. Somewhere possession will also help in redressing this oral family settlement. Okay, because brothers will not simply mutate the names. They will also take possession of the property and then mutate the names. So, courts have adequately discussed this oral family settlement, which is generally done in India. Now, coming to written family memorandum of settlement. Earlier, because it was oral, registration was not at all necessary. But because it is in writing, registration is necessary or not is the interesting question here. When family settlement is done, listen carefully, I am using the same example. Registration is compulsory as per the Registration Act and the Transfer of Property Act if the mother and the daughter relinquishes their right in favor of the brothers. So therefore, the 2 brothers are acquiring the right out of the 4 properties, and the mother and the sister are relinquishing the right, that is voluntarily giving up the right. Therefore, registration is necessary. Therefore, mother and sister has to execute a relinquishing deed containing the contents of the memorandum of family settlement or the terms of the memorandum of the family settlement. So what is the principle here? When it is written, the principle of registration is coming up. When it is oral, the principle of estoppel is coming up. So courts have adequately discussed this in the past 70 years, and it is settled law that courts will always lean towards family settlement. Remember this, because it is a concept that courts developed in order to decrease the disputes. So once the family members acted on the family settlement, it is very difficult for them to come to court and question the family settlement. Courts are always in favor of family settlement. No doubt, courts are much smarter than the litigants. If the litigants try to play games with the courts know how to deal with it. Courts have 100 devices and court speaks in 100 languages. Therefore, whatsoever may be the type of family settlement, whether it is oral or whether it is in writing, these are the principles that are applied. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment. If you want a copy of the Memorandum of Family Settlement, pro forma of the Memorandum of Family Settlement, kindly mail me. I will send a copy. Thank you.